Hello, everyone, and welcome once again on this beautiful day to Immigration Talk Show. I'm happy to be here. I'm Nipasa, your host for this lined up session, and soon our guest is going to join us. So stay with us, all right? And before we head on with today's discussion, I have this very important disclaimer, and that is by watching our videos, you agree and understand that the information provided by our experts and attorneys, including comments and replies from users, is not legal advice. Use of information is at your own risk. So, friends, happy to tell you and welcome you. We are streaming live right now on YouTube, but you can also check us out on LinkedIn, Facebook, X, and also Instagram. And please feel free to join us. You can do so by commenting wherever you're watching us. And otherwise, you can call us on this number because, yes, it is an Ask Me Anything session that is lined up for today's hour. And the phone number is 425-436-6335, and the access code is 988-888. So do join us. And today's topic of discussion, since it is the H1B season, nothing could be more right. So if you got any questions and you want answers, join us in this exclusive question and answer round with none other than our guest for today. And our guest is going to be Sophie Alcorn, the founder of Alcorn Immigration Law, with offices in Mountain View, California, Houston, Texas, and New York City. And she has been recognized as a top 10 immigration attorney in the state of California. And she's also the host of the Sophie Alcorn podcast and author of the best selling Ask Sophie, the Founder's Guide to Visas and Green Cards. So I'm happy to welcome her back once again. Hi, Sophie. How are you doing today?
Hi, Pasa. It's lovely to be back. I'm doing well, thank you. And thank you for having me.
I'm excited too. So, how are you doing and how's it going? I mean, it's the H1B season, busy for you, and you also have
Um,
podcasts going on. Tell us more.
oh, thank you. It's been quite a busy time. Immigration is definitely in the news all the time, and I'm happy to discuss more, but we're starting to maybe see some enforcement changes that are kind of changing the landscape. So a lot of people have a lot of questions, and that's definitely keeping us busy. That paired with H1B season, which we're in the thick of right now. It opened up on March 7th and it's open until March 24th. So a little bit less than 1 week. Today is our very last cutoff day for any new H1B cap registrations for new clients. So we're adapting to the changing conditions, learning and growing, and it's been a busy time.
But is it true that this year's H1B is a little slower than previous years because, firstly, the fee hike and so many other things, administration change, rules getting stricter, so much scrutiny everywhere? What would you like to say?
It could be. Only the final numbers will tell. We have actually kept pace with last year. And I was quite pleased with that we're able to help that many people. But I had been anticipating in December that it might be slower than last year. And I believe last year there were about 500,000 registrants, approximately maybe 485 or 483, I think. So I'll be curious to see, because I think there's a couple different trends going on that could pull the numbers in different directions. One is that immigration is in the news, but in more of a fear-mongering way. So that might mean that newer businesses that hadn't dabbled in immigration yet might not be willing to try it in this environment. But on the other hand, for the players who understand the game and who have done it before, Elon Musk's comments last December that the H1B program would be protected, and kind of the slow start on any changes in business immigration in the White House, kind of, I think, give some coverage to some of the bigger companies to put in as many, if not more people than last year. So, and then on a small business level, what I'm seeing with early stage startups is there's starting to be some more additional movement in the economy, in the tech economy, on the small business side of things. Whereas before, it was like, no, interest rates are really high. We can't afford to add to our headcount right now. Let's get an AI robot coder. Now it's like, well, we really need a person for this. We have the right person. We see some money coming in or some investment coming in. We think the economy is headed for improvement. So I'm starting to see those signs of the little seedlings of economic growth starting to crop up, and they might take a couple of years to fully grow, but I'm seeing trends in that direction, which is exciting.
Right, right. So we'll just have to wait a little bit. I think the results will be out as in by the end of the month, right? 31st of March.
Yeah. Typically, if things repeat the way we remember from last year, probably on like Saturday the 29th or Sunday the 30th of March, the attorney inboxes and the company inboxes will be full of the notifications of who got selected. But it comes in waves and it could trickle in for several days. So you think you'll know by April 1st, but it's not necessarily guaranteed. This year, April 1st is on a Tuesday. So hopefully by the end of that Monday, we'll know everybody who got selected in this first batch. But the other thing for the beneficiaries who are seeking jobs to keep in mind is we don't know how many lotteries there are going to be, and you don't find out if you were not selected. So sometimes it can take employers some time to be able to process all the details, determine what plan they want to make for each individual, and actually release the information about if somebody was selected or not. So usually if you're selected, you'll know right away. If you're not selected, you're going to have to wait a couple weeks to figure out what to do. But I have a series of webinars coming up on both of those topics, actually. One of them is called What to Do If You Were Selected in the H1B Lottery. And then the other one is called What to Do If You Were Not Selected in the H1B Lottery. So those are going to be on April 2nd and April 3rd. And I'll provide that link to your team, Nipasa, in case it's helpful.
Thank you so much. Yes, and team, if you could also put that up, because it's really nice that Sophie, you're here and that you do podcasts, and nothing could benefit more than, I mean, all these information so beneficial for all our audience.
Thank
And
you.
that said, I'm very happy to see many folks join us again. So happy that they have joined us because it's a Ask Me Anything session, AMA session. So, folks, please feel free to ask your questions. You may have many. And yes, this is Sophie Alcorn, the founder of Alcorn Law. So, Rag says, hello, Nipa and Sophie. Hi, Rag. Thank you so much for joining us. It's always nice to see you pop up. He's one of our very regular viewers. So, Rag, I hope someday you will join us on call too. And yes, we have Komal saying hello, hello, Komal. And are you ready for questions, Sophie?
Sure, I'm happy to. We can dive in. Absolutely.
Okay, so let's go with our first one, Ram. Ram is asking, my employer filed my H1B petition, but they missed including one of my past job experiences. Can we fix this mistake after submission, or should I withdraw the application and refile?
That's interesting. Ram, I appreciate the question. It might actually not even be a problem. To get an H1B approved, you basically have to show that there's a company offering a specialty occupation position and that there's a beneficiary, you, a person with at least a bachelor's degree in a related field or higher or equivalent experience, and that they're going to pay you the prevailing wage. So having all of your experiences in there is actually not required. You could theoretically get an H1B approved for somebody for a software engineering job if you simply showed their computer science degree for their bachelor's without proving any of the other things they did on their work experience. So I think it will actually be okay, but I would urge you in this situation to speak to your company attorney and just confirm. Your past job experience does really matter for the perm process if you're being sponsored for a green card. But any omissions in the H1B that are later presented in the perm are not necessarily a problem. You're still telling the truth that you did these things in the past. but you just didn't need them all for the H1B. So that's an interesting question. I understand you're concerned, but it might actually be completely fine. So get more information, and I could see a scenario in which, as long as there was not a misrepresentation, which you would obviously want to correct, but if it was simply an omission and you qualified without it, then you might be able to just move forward fine with that approval.
Okay, that's interesting. But what if someone later finds out, and would that cause a problem?
That's what I'm thinking. I don't think it matters because it wasn't required and it got approved anyway. So, I mean, if on an extension you want to include that information out of an abundance of caution and thoroughness, I think it would be fine and it wouldn't cause a conflict. And you could even have the lawyer explain at that time, additional information confirming Brown's eligibility is included as XYZ, evidencing his prior role, which was not originally submitted in the first petition, but is submitted here for comprehensiveness. Like, there's a way to explain it that's totally okay. So I think it's possible for it to all work.
All right. So all the best, Ram, and not to worry, I guess. Don't be too anxious about this. So all the best. We have Komal with a question. So hi once again, Komal. And Komal, let me tell you to all folks out there that you can also join us on call to ask your questions on call to Sophie directly. And that you can do by calling us on this number, which is displayed on the screen above. 425-436-6335, and the access code is 988-888. So also, so yes, let's go to the question. Komal is asking chances to win lottery per candidate this year.
We don't know. We won't know till it's over. If it's anything like last year, it's about 25 to 30% for people with the US master's cap, where you got a master's degree or higher from a qualifying US college or university, and 15 to 23% for people with under bachelor's degrees or equivalents from anywhere in the world. So you get that extra boost if you had that advanced degree from the US, but everybody else gets an equal chance, regardless of country of birth, regardless of country of citizenship. So we'll see. This is where those numbers come into play that we were chatting about earlier. If the numbers hold true from last year, and if there are about 480,000 registrants for 85,000 spots, well, you can do the math, right? It's about 15 to 20% chances overall for everybody. So, but we'll find out hopefully by April 1st. You'll know if you were selected, at least in the initial batch. And then if a lot of companies, here's maybe some good news for the people who aren't selected. Look, if the H1Bs are adjudicated to stricter standards than they were last year, and if there is a higher RFE and denial rate, then more people who are not selected in the initial batch might have a chance of being selected in subsequent batches. So maybe a silver lining if you're not selected at first. I wish everybody could just get selected,
I know, but really nice. This is an interesting POV. Thank you so much, Sophie, for sharing that as well. And Komal, we would really like to know where you have joined us from. In India or from the United States, where, please tell us, and do join us on call. And don't forget to like, share, and subscribe to our channel as well, friends who have joined us. So our handle is @Immigration Talk Show. All right, so let's move on now. Let's go to Isaac. Isaac is asking, potential travel ban to Venezuela can impact H1B applicants if they need to travel to Venezuela to receive the visa. That's a question.
Great question. Okay. So far, I am not aware of any travel bans that have happened, although, the news is always changing. So if I just looked it up as of 2 hours ago. Okay, it's under consideration, but no decisions have been made yet. So it might be happening very soon. Now, there's a couple of different ways they can do this. what they did in the first administration was they decided to select about 10 to 15 countries, and they had various ways they wrote this, right? And originally it was called a Muslim ban, and it went up to the Supreme Court and it got litigated for years. And eventually at the end of Trump 1.0, they were able to come up with legally acceptable ways to make the ban happen for certain people in certain countries. And that mostly had to do with people's countries of citizenship and what passports they had. Although in the past, for various reasons, there have been ways that if somebody visited Iran or Cuba, they might be subject to additional screenings. So from the Independent, the UK newspaper 2 days ago, there's this story talking about how they might be expanding the travel ban to include 43 countries, according to one report. They have not issued it yet. No decision has been made. It's within the State Department. It looks like the current draft has 3 sections, red, orange, and yellow, to denote the level of restriction. Venezuela would be on the red list, along with 10 other countries, which would be entirely forbidden from entering the US. Any citizens of Afghanistan, Bhutan, Cuba, Iran, Libya, North Korea, Somalia, Sudan, Syria, Venezuela, and Yemen. If this draft happens, then any of those citizens would not be able to enter the United States. So not only if you're trying to get an H1B, should you not go back to Venezuela, but if you're a citizen of Venezuela, you might just want to stay in the US and only do a change of status and not leave. Because if you leave, you might not be able to get in. And there's even a question about whether dual citizens, one of my friends is a dual citizen of Iran and the United States who lives in the United States. If that person leaves, can they come back in? Well, under the first travel ban, US citizens and permanent residents were excluded, but we don't know how they're going to be writing this ban. Now, there's 2 more. I just want to go through the other groupings really quickly. So then the yellow list, so there's the red list, then the yellow list would be 10 more countries. The orange list would be 10 more countries, including Russia, for example. And those individuals would all have to have in-person individuals to get a visa. And then there's a yellow list of 22 countries, mostly in Africa, where they're considering giving 60 days to address their concerns against various alleged deficiencies. And so, I know a lot of our listeners are in India. India is not on any of these lists. And a bunch of people are working on this. So we don't know if and when it'll happen, but if you are a Venezuelan citizen, if this ban happens the way it has been reported, and there could be a lot of changes, but if all of that occurred, then you would not be able to enter the United States on October, even if you are selected in the H1B lottery. So definitely, stay abreast of those updates.
Thank you so much. And it's a little sad and what to say,
Yeah.
very uncertain a situation, I would say. But I think it's best not to travel right now. If you're in the US, stay in the US.
Yeah.
That's all we can say for now. So, Isaac, thank you for your question. If you have more questions, please feel free to join us. But all the best. Let's go on to our next. Pratap is asking, I went to US with H1B visa on September 24 and returned to India on November 24, okay, year 2024, due to project when went on hold. My employer didn't process single payroll due to this. The project is going to start again now. I have to go to US now. I was in, will they ask pay stubs at US immigration?
They might,
They might.
but they might not. So you should just try it. And maybe what you could do to be extra prepared is get a letter from the employer explaining the situation, so that at the airport, when you come in, if any questions are raised, then you can get out that letter and show it to them. I wouldn't necessarily be like, here's my letter. But if they're like, what happened on the last trip? Then you can be like, oh, this is from my employer to explain what happened. And then your employer should have their immigration lawyer write that letter to make sure it has the correct language for you. But I still think you should be able to get in this situation, even without pay stubs, but because I understand what happened, but you definitely want to have some documentation if asked.
But is it legal or fair? I mean, not to be paid. It was 2 months, September to November.
No, you should have been paid for all the time you were in the US, and benching is not allowed. So the employer, I believe, messed up in this situation. But will it prejudice you and prevent you from getting in? I don't think so.
But it could cause trouble to the employer, right?
Yeah.
Okay. So, Pratap, you're safe. All the best for your project. Okay. Now we have Bhavana saying, "Hi, ma'am. My employer hasn't filed files yet. They said they are going to file within 2 to 3 days. Will filing late affect the lottery chances?"
In the olden days, people suspected that it did when we were mailing in paper petitions, because the speculation was that they were granted not randomly, but on a first come, first served basis. Ever since the lottery has been electronic, they run the lottery once after the lottery window has closed. So as long as your employer gets the registration done by the 24th, when the portal closes, you'll be fine and you'll have an equal chance compared to anybody else. So they don't have to rush to do it tomorrow. There's no added advantage. It's best to make sure it's properly done.
Okay. All the best, Bhavana. And now we have Ryan saying hi. Hey. Hey, Ryan. Hi to you too. If you have any questions, please feel free to join us. You can join us on call as well. And next we have Pavan Kumar. If an F1 student's OPT expires on June 30th this year, are they and they are selected in the H1B lottery for fiscal year 2026 with a petition filed on April 1st, 2025. But their H1B petition is not approved until July 15th this year. Can they still take advantage of the cap gap provision to extend their F1 status? And if so, what are the specific requirements and deadlines they must meet to maintain their status and avoid any gaps in employment authorization?
Okay. Can I see the beginning of the question again? Or I'm going to pull it up on the side. I want to get all the dates in my mind. Okay. Yeah. So they expire June 30th. So you have to file the H1B petition by June 30th, even though you have a theoretical 60-day F1 grace period beyond June 30th to take advantage of cap gap. You do need the employer to file by June 30th. Let's go to the next part of the question, please. If it's not approved until July 15th, can you still take advantage of cap gap? Absolutely. The only requirement for cap gap is that your H1B is filed while your STEM OPT, or if you're not eligible for STEM OPT, your regular OPT is still valid, and it is okay and normal for the H1B adjudication to drag on beyond the end of the work permit period. And yes, in this situation, you would be able to take advantage of cap gap. They actually extended cap gap this year, so that even if your employer won't pay for premium processing and the H1B takes until, I don't know, December or January, you would still be able to continue working at your current employer. I believe that cap gap will now let you work for 6 months beyond October 1st. So they extended the cap gap provision. And the main thing with cap gap is, keep working. Don't travel internationally until it's approved, and then you do the visa stamping. And you can't get, you have to do a change of status to get cap gap, but you should be fine in this situation.
All right, so that's good news then for Pavan. All the best. Well, Isaac is back again with another question, or it's the same question, I think. But yeah, a potential travel ban to receive the visa. Yeah, it's the same question. All right, so let's move on now to Ishita. Ishita is asking, with recent changes in immigration rules, is premium processing worth it this year? Or does that trigger a higher chance of an RFE?
That's a very interesting question. Uh, we actually don't know. So, um, if I think it really depends whether you should use it on a lot of personal situation factors that are not legal. And so, like, if you're outside of the US and you really know if you need to be moving here in October, maybe it's worth it to pay for it, for you and your employer to have that clarity about if you're coming for sure. If you're in the US and you're on cap gap and maybe you have a weird major and you're trying to go for some job that doesn't directly qualify, maybe it's best not to use premium processing and see how the adjudications shake out and then decide, because you can always add in premium processing later. That's an opportunity that you have. So some people like to take the strategy of, well, let's not use it at first. Let's see how things go. Let other people give you the guinea pigs. And then if we're getting in a rush, we can add it later. So that's fine. And then other people are like, we just want to know now. This is a real job, a real company, the right person. We just need to get them approved. Let's just find out. So it really depends.
Okay. All right. So do you suggest her to wait first? But I
I think it's your employer's prerogative first if they want to pay for it, find out what they're intending to do. And then if they're not willing to pay for it and you really want it, that's the one thing in H1Bs that the beneficiary can pay for directly. So you could always choose to add it in if you're feeling anxious.
Okay. All right. Thank you so much, Sophie, for taking these up, and also this one for Ishita. So we have V2 now. V2 is saying, hello, Sophie. I'm on H1B and have applied for COS with marriage based green card 485, I-130, 765, I-131, and EAD is approved. Can I use the EAD to work without impacting your pending COS and green card applications?
No, if you are switching, it's kind of a complicated gray area, and you should really speak to the counsel for your company about this. But kind of the way that most immigration lawyers approach this is if your company is switching your I-9 employment records to being based on your EAD instead of your H1B, you pick one or the other. And so if there's any problem with your I-485 adjudication, then there would be an argument that you would no longer have your H1B. So it may be safest in this environment to just stick with your H1B and only use that until your green card is approved, unless there's some extenuating circumstance. But if you do it, know that there's a risk. So keep that in mind.
Okay. All the best, V2. Thank you so much for joining. Folks out there, do join us on call or keep commenting. It's really nice to have you join us. And do not forget to subscribe to our channel. Our handle is at Immigration Talk Show. Check us out. We are not just on YouTube, but also on LinkedIn, Facebook, X, and also on Instagram. And don't you also forget to check out attorney Sophie Alcorn, and do check out Alcorn Law. She's also a very amazing podcaster, I would say, Sophie Alcorn. So you should watch out for the Sophie Alcorn podcast. And you can also call her, contact her in case you want a one-on-one discussion, a consultation. Please feel free to contact attorney Sophie Alcorn, and her phone number is 855-644-2581. But I think it's best to email her. So hello at alcorn.law, and do go visit www.alcorn.law. That said, once again, Sophie, are you ready for more questions?
Let's do it. Let's do it. I'm ready.
Okay, we have Trisha with a lot of questions, I think. Yes, so let's take it up. If an H1B petitioner files a successive H1B petition for an employee who is already in H1B status with another petitioner, but the successive petition is filed more than 180 days before the employee's current H1B petition expires, and the employee's current H1B petition is subsequently revoked or denied. Can the employee still port to the new H1B petition and begin working for the new petitioner? Okay, and if so, what are the specific requirements and procedures that must be followed to ensure a seamless transition and avoid any gaps in employment authorization?
Well, Tricia, thank you. This is quite a comprehensive question, and I will see what I can do to unpack it for you, and we'll figure it out together. So, okay, so it seems that I think it depends on if you're at the company that was originally employing the person or the company that wants to hire the person. I think you're at the company that wants to hire the person. So let's just assume you're the one who filed the successive H1B petition. So basically, the employee's current H1B petition is revoked or denied. Can they port? Okay, I think that the main thing is, has the person been considered to be maintaining status since entry? And so I don't know all the timing, and maybe this is a longer conversation. You're welcome to reach out to me. We can figure it out. But I think in general, if the underlying petition was revoked, then the person would be out of status. And so we want to know how many days they've been out of status. So we want to know when they most recently entered the United States. And I believe that's why you mentioned the 180 days, because there's this rule that if somebody's been in the US for less than 180 days and they leave, they can get back in if they've been out of status. If they've been out of status between 180 days and 1 year and they leave, they can't come back in for 3 years. And if they've been out of status more than 1 year and they leave, they can't come back in for 10 years. So I believe that's why you brought that up. So it sounds to me in this scenario that I don't actually know. So we have to recalculate that together. But in an ideal world, this person would have a visa stamp in their passport. Less than 180 days have passed since they entered the United States. The new H1B is approved and they leave and they simply come back in and they can go on payroll, and that would correct everything in this situation probably. But I'm not sure if that's all your facts. So you're welcome to reach out to me. hello@alcorn.law, as Nipasa mentioned, and yeah, happy to help you figure that one out in more detail.
Right. Every case is different and it needs a lot of attention, right, Sophie? So I'm sure, I mean, Trisha, it would be best to contact attorney Sophie Alcorn and you can email her. So let's have Rag. Wow, Rag, you have a question now. So Rag is asking, will the US consulate approve a standalone cap exempt H1B petition from the Build Fellowship, or is an additional concurrent H1B required to avoid additional scrutiny?
Great question. Interesting question. I don't represent the Build Fellowship. I've worked with them a lot in the past for the second concurrent H1B at the private company that would otherwise not be cap exempt. And in those situations, we can get through consular processing. We have a way to do that. In this situation, I would definitely encourage you to talk to the Build Fellowship about what they're seeing on the ground with all their candidates that do not have concurrent H1Bs. I believe in this environment, the more cautious approach would be to stay in the US only through a change of status and not consular process a new visa stamp. Because if you're going to a visa interview, right, and they're like, well, what is this job? How are you going to pay for yourself? You know, how many hours a week are you working, right? It's more of a minor position. So I would caution you to get more information and probably stay on the safe side in this environment.
Right. Thank you, Rag. And if you haven't already subscribed to us, do subscribe. I know you have, but share our content, please, and ask more friends to join in. and maybe ask their questions, because there wouldn't be another opportunity like this. So thank you so much, Sophie, once again for doing this.
Thank
And
you.
Pavan says thanks a lot. Thank you, Pavan, too, for joining. If you have more questions, keep them coming. Now we have V2 also saying thank you, Sophie and Nipasa, for taking up. Thank you, V2. And if you have more questions, let's take up Raghav, another comprehensive one. If an H1B petitioner submits a petition with a labor condition application that contains a material error, such as an incorrect prevailing wage or incorrect job location, but the petitioner corrects the error and submits a new LCA before the H1B petition is adjudicated, can the corrected LCA be considered as part of the initial petition? And if so, what are the specific procedures and requirements for submitting corrected supported documentation to USCIS?
Wow, Nipasa, your audience is so advanced with immigration. They're encountering such complex situations. This is like the master's class. Rob, I don't know. You stumped me there. This is a complicated one. It would require a lot of legal research on the details of are LCAs considered evidence that must predate the filing of the petition. And I could see legal arguments in either direction. And this is something that my attorneys and I would have to look into for one of our clients and conduct legal research on the exact specifics. So if you are the human resources person for an employer, definitely ask your immigration lawyer. You're welcome to reach out if you need a second opinion. If this is your employer, then the best thing is to talk to their immigration counsel and try to make sure that everything is handled properly there. So I wish you the best for this.
Right. All the best, Raghav. And it's true, Sophie, sometimes we get these questions, and I mean, we're not experts. Attorneys like you are. And I mean, I can only imagine
I don't
what
know
you
everything.
I know, right? So we have ZQ also having a question for us. So, are the green cards of elderly Indians being taken away by CBP when they want to re-enter the US? I heard that in the news. Me too.
Oh my gosh, it's so sad. I don't know. The main thing to know if your parents are, or if you are in that situation and you want to come to the United States, is they can't force you to give up your green card at the airport. You have the right to decline. And why would that situation happen? Well, from a legal perspective, the CBP officers would be saying, we believe you've not spent enough time here. We believe that you intend to abandon your permanent residence in the United States. And then they'll shove papers in the person's face and force them to sign, even when the person might not know what they're signing. So and I believe, yeah. So the I-407, I see the additional question. That is the form that somebody would sign if they are choosing voluntarily to give up their green card. So extreme pressure could force somebody to sign this, and then legally it looks like they've voluntarily given up their green cards. So what you can do, one thing is just for everybody to know their rights. The I-407 does not have to be signed. And if you don't, then the worst case scenario is you get to have the opportunity to talk to a judge in court about why you are still living in the US and you haven't given up your green card. You have that right. So they can't just force you out of the airport. On a more practical level, this is a lot more work, but maybe consider having an adult child in the family actually go back home to escort mom and dad here, so they're not alone when they go through secondary inspections in the airport, and you can stay together as a family group. Another thing that you could do is consider having evidence with you at the airport that you have been permanently residing in the United States. Any income here, any taxes here, health insurance, bills, lease, mortgage, banking statements, Any reasons for a more extended, more recent trip, like if you had to be gone longer because of a medical care procedure. So there's ways to explain that you're still living here and that the most recent absence was, unusual, and now you're coming back home. So that's the situation. So hopefully that's helpful.
Yes, I hope so also. And Sophie, is it true that, in the airport you are not, allowed to, I mean, allowed to speak to your attorney or anybody legal as well? Is that true? Like if I don't want to
You
answer
should.
from
You
my attorney.
should. You should be able to say, I want to speak to my attorney. Now, that being said, if you're in secondary inspections and they're not letting you use your cell phone, what practical way is there to deal with that situation? That's why I was suggesting maybe an adult child could accompany. I wish I had time to just go on airplanes and help people, enter the United States and be at their side and be in their family group going through immigration. But I don't know of any immigration attorneys that can do that. But that would be the way, to have your attorney by your side. So I'm just brainstorming ways to try to be helpful here.
I wish, like a fairy, like just wave your
Right.
wand and you would be present. Hey, come
And
here
then I
over
could finally
there.
have a reason. Then I could have a reason to justify a private jet, which would be fun.
Well, that would be so cool.
Yeah.
But anyway, yes, ZQ, thank you for your questions. Really nice. There is also a law that if you leave the US for more than 180 days, then you are considered out of the US.
Okay. So that's a different thing. That's related. So basically, this is a law about the burden of proof, whose job it is to prove that you're living here or not living here. So if you're gone less than 180 days and you come back in and they're hassling you at the airport, then they can say, why are you coming in? And then you would say, because I live here and it's your job. You guys have to prove that I don't live here. So ha, 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 ha. So it's way harder for them to do that if you've been gone less than 180 days. If you've been gone more than 180 days, then it's the burden of proof shifts, which is like a law school thing that we learned. So it becomes your job to prove that you actually still live here. So that's why all of those medical exams, doctor's reports, health insurance, residential bills, all of that can be helpful evidence. However, if the Customs and Border Protection officers at the airport have said, okay, it's your burden, you were gone 181 days, it's your job to prove that you still live here, and then you give your reasons, and then say, we don't believe you have met your burden of proof, we do not believe you live here, and then they try to pressure you and they say, sign this form I-9, I-407 to give up your green card, you have the right to say no. And then if they still want to push it, they can say, okay, we're going to send you to immigration court to see a judge. You can take it up with the judge. But then they have to let you into the country. You'll get a court date in a year. It's going to take 10 years to fight the case. Like, that is the better option, right? And then you can get an attorney for removal defense, but you have the right to have a trial in front of a judge proving why you still live here. So those are your rights. You don't have to give them up.
Really nice. Thank you so much, Sophie, for clearing that out. And thank you, ZQ. Very interesting questions you have. And now let's take up Deepu's question. I'm looking for H1B sponsorship and would like some guidance on finding a sponsor. Could you advise me on the best approach or connect me with the potential sponsors?
Interesting question. Okay. So I can tell you what I see in the field, but my role is I get hired by companies that are already choosing to hire international candidates and sponsor them, or I get hired by international candidates who want to self-sponsor. So I'm not really in the business of job matching. That being said, I know there are a number of websites that have done something called a Freedom of Information Act request, where they get the data from anything that an employer has sponsored before in terms of an H1B labor condition application or the perm process of a green card. because the Department of Labor has to give that information over in a Freedom of Information Act request. It's not confidential. So there's websites inventorying year by year which companies sponsor and how many people. So that's often a useful starting point if you want to do a breadth first search and figure out, okay, it's going to be Wipro, Microsoft, Amazon, or whatever, right? And then you're just like going down the list, applying for jobs that way. That's one way to do it. The other option that I see people do effectively is be really good at something, be passionate about a specific sub-industry, network online, make connections, help people, volunteer, create relationships, match with an employer that really truly appreciates you. And then they're willing to put you into the process because they understand the value that you can bring. And if you're abroad, you can start working them as a contractor from outside of the United States. And if you're in the US, most people would be an F1 student and you have your OPT or your CPT or your STEM OPT, and those would be ways to, test drive the employment and ask them to sponsor you. So those are usually how people begin the process.
Very nice. So, Sophie, I mean, do you have any client maybe who are extraordinary and you would like to share a short story about them as well?
Sure. We have really, really cool, inspiring clients. And not all of them thought they were extraordinary when they hired us. So that's another thing we do, is evaluating people to help qualify them for these more rare types of visas and green cards, such as the O1A visa for extraordinary ability. And just this morning when I woke up, I found out that a client in London got their O1 visa approved today. So now they can move here with their spouse in 4 weeks and start their job in San Francisco and eventually probably start the green card process. So they're very, very excited. And that interview went very smoothly. They said swimmingly well. So it is possible, even in this environment. We have success stories every day. So I just want people to know that even with the fear mongering in the news, like 98% of the time, the system is still working smoothly and correctly. So definitely keep that in mind. But these extraordinary visas can be for anybody in any field, pretty much, except for law. But I guess I would have to position a lawyer as an expert person in the business of law, for example, to qualify them. But engineers can get it, UX, UI designers, artists, musicians, entrepreneurs, business, growth hackers. Like there's so many jobs that can qualify. And in order to get one of these visas, well, first of all, the benefits are, unlike the H1B, there's no lottery, so you can apply any time of year. Often the visas last for 3 to 5 years at a time. And unlike the H1B, you do not max out at 6 years. There's unlimited O1 extensions. They just improved the O1 extensions. It used to be that you could get it extended for 1 year at a time beyond the initial 3 years, but now the extensions are available for 3 years at a time, which is really great. And then the other cool thing about O1s is you're not necessarily limited to one employer. You can have an agent petition for you, in which case you're allowed to work at a variety of roles, including self-employment, off of an itinerary of services. So it provides a lot more job flexibility. So some of the factors we look for are, what are you really good at doing? In what companies have you done this where you've had a leading or critical role to manage a bunch of people or run a very complicated project? What are your actual launches that you've been accountable for, and how have those not only affected your research or your company, but also your industry, and how are other experts copying you or using your work or doing things differently as a result? Have you ever made a high amount of money, not compared to the US, but compared to other people during that time and in that place doing a similar job? Are you part of any groups or clubs that are hard to get into? Did any of your work win any prizes? So there's a lot. Oh, did you write any articles? But I can even use speeches that you gave. So we just want to prove 3 of those points. And then you could get an O1, and it's about a 5 to 6 month process if you're outside of the United States. And it's really lovely. So I appreciate you bringing that up. It's important to remember that in this H1B season, that there are alternatives that are for the qualifying group of people. It's much more reliable and gives a lot more freedom.
Absolutely. Thank you so much. Also, Sophie, for highlighting that, because, I want folks out there who are watching us to feel hopeful and not I
Yeah.
mean, don't think too low of yourself. Maybe you are extraordinary at your field and you don't really know. Find out.
Right. Yeah. Have a consultation with us. I have a complimentary online class to become prepared. I used to charge $1,000 for it, but I decided to gift it to everybody over the holidays in December. I'll provide that link as well. But now 1,000 people have taken it, and it's all about how to become qualified for extraordinary ability for an O1A, an EB1A green card, or an EB2 national interest waiver green card. We provide assessments as well if you want to reach out. But it's just most people are so modest and humble, Nipasa. And then if you're not American, like here we're like, oh, brag, fake till you make it. I'm a thought leader. Here I am on TikTok, right? Like it's very different culturally in the rest of the world where people are taught to be respectful and don't say anything unless you're 110% confident, and to not stick your neck out, tall poppy syndrome, all these other things, right? So a lot of people who might qualify don't know that they might qualify, so it's worth reaching out or learning more and exploring it further.
Absolutely. Thank you, Sophie. And I think we should quickly take up more comments since we have
Okay.
questions and a little less time, I think.
All
So this is
right.
Caroline. My I-140 is already filed on February 2024. I have now found a new employer willing to file my non-capped H1B. Will it be okay to apply for a visa or will my visa get denied because of I-140 filing?
No. The the H1B is a dual intent visa, and it is 100% compatible with an I-140. But you might want to wait to get the I-140 approved before you before you decide to leave that current employer and switch to a non-capped H1B. I also don't know why you have an I-140 but not an H1B yet. That's a pretty rare situation. So I'm not sure. You should get help, more help, and maybe the new company's immigration lawyer could help you, or you're welcome to reach out to us. I can try to answer. But just the literal question you asked, will it be okay to apply for a non-capped H1B, or will the non-capped H1B get denied because of the I-140? The I-140 would not be a reason for the non-capped H1B to be denied. So hopefully that's helpful to you.
Thank you, Sophie. And thank you, Caroline. Please don't forget to subscribe to us. We are at Immigration Talk Show, and this goes out to all folks out there who are watching us. If you haven't already subscribed to us, do subscribe to us. And also don't forget to share our content, especially this link, this chat we're having with attorney Sophie Alcorn. And Sam says, thank you. Thank you too. Thank you, Deepu. And I think we should take up a couple more questions and did we answer this already? Rag was asking, what are the other alternatives to the built
Hmm.
fellowship cap exempt H1B?
I'm hearing about more. There's one called the Parachute Project. I believe there might be a couple more, but I don't know their names right now. And then also just getting your own cap exempt job is a possibility. So that could be working at a US university part-time or full-time, working at a nonprofit teaching hospital affiliated with a US university, working for a nonprofit research institution. And under the H1B modernization rule, I am open to taking test cases for companies such as startups that want to qualify as a cap exempt organization directly, simply by having you do several hours of work a week via telework for a qualifying organization. So there's a lot of new possibilities for how to get cap exempt status at this point.
Okay. Thank you, Rag, for your question, and thank you, Sophie. Sophie, we just have a few more questions from our Facebook group. So before
Okay,
you leave, we'll just quickly address them as well.
good.
So this first one. Hi, all. My H1B is set to renewal this year, September 30th. I have not traveled to US, and now my company is asking to get transfer since they don't have any active PO to travel. Confused what to do? Please suggest what can be done.
I don't really understand your question. I'm so sorry. Your H1B looks like it's going to expire, but you've never used it. and now the company wants to transfer you. Maybe they don't have a job for you to do here. I think that if you're out of the US and the H1B expires, it's really not a big deal, because you can always, if you got counted in the lottery, you can always transfer your H1B to another company in the future. Plus, you can recapture any time spent outside of the United States. So I think you do have options in case you want to transfer this to a new opportunity in the future.
Okay. Thank you, Sophie, for taking that up. I wish I knew the person's name also. And this one is also from another anonymous participant. Hello, everyone. I'm seeking some advice. I have two sons, one aged 16 and the other 7, and I have been living in US for the past 13 years on an H1B visa. My I-140 priority date is February 2019 under the EB2 category. My 16-year-old is about to complete 10th grade, and I'm considering returning to India for 2 years to gain managerial experience and then reapplying under the EB1 category to expedite my green card process, ensuring that my son does not age out. Would this be a viable option?
Yeah, it would be. The other thing that people do is they try to become qualified for an EB1A, which is one of the reasons why I created my Alcorn Academy course that I shared the link to. But if that's not right for everybody, this is an alternative that could theoretically work based on what you've described. So, and then, I mean, it's a lot for your family, but also, your 16-year-old doesn't have to be in India with you. You just have to have the required 1 year of work experience in India, and then you could transfer back to the US. But you just have to make sure that the company is willing to go along with the entire plan before you uproot yourselves. Make sure you have buy-in from them.
All right. Thank you, Sophie. Thank you for taking that up.
Mm-hmm.
Let's go on to our next. Looking for insights from anyone who recently went through H4 visa stamping in a similar situation. I'm currently on H4, and my husband recently got his H1B approved along with our H4 extensions. This June, I plan to travel to India with my 14-year-old son. I will be carrying my I-797 approval notices for both of us, along with my husband's I-797. I'm eligible for Dropbox, while my son will need to attend an in person interview. My husband does not have his H1B visa stamped and will not be traveling with us. So, where
Okay.
there are.
No, go ahead. Go ahead.
I'm just reading. Has anyone been in a similar situation this year? And were there any issues with H4 visa stamping due to the primary H1B holder not having a visa stamp?
So I will just say that theoretically, everything you're saying checks out and is a legitimate situation and makes sense. And that is how it should work, and it should work well. That being said, my attorneys and my firm and I yesterday decided that our cautionary advice that we're going to tell people is that we recommend only essential travel. There's too much randomness and uncertainty, and the costs of getting stuck outside the United States are too high. So if there's an essential business reason, or there's a very important family member situation to address, I get it, by all means. But if it's something that could be canceled, it might be prudent to wait past June to see how the situation evolves and hold off on international travel. I know it's hard to get those appointments. I know that traveling is great, but I would just really want to make sure that your family stays safe and together. So please keep that in mind before you depart.
Okay, I think we should go on to this next one. Thank you so much, Sophie. I'm seeking assistance from anyone with experience in this matter. I'm currently in the process of changing my J1 visa to H1B status within the US without returning to my home country. I recently got married, and my home country may be on a travel ban list. My question is If I obtain the H1B visa, will the ban impact my wife's ability to secure an H4 visa, considering I do not plan to travel back home? Or can the ban affect her H4 visa status if I have an active H1B?
Okay, so the main thing for you to figure out coming from J1 is if you're subject to the 212E 2-year home residence requirement. I believe you're not, because otherwise you wouldn't have been able to get, be able to get an H1B. Um, so, but then ideally you would simply file for a change of status inside the United States without leaving if the employer is willing to do it. That would be the safest thing in this present situation, because if you leave and the travel ban happens and you're doing your H-1B visa stamping, you might not be able to get in. But if you get the H-1B visa or status and your wife is not from your country, she should still be able to leave, get an H-4 visa, and come back in for her home country. But if she's from the same country as you, then she should also not do that. If she's in the United States, she should simply do a change of status. But if you're inside and she's outside, then she ought to try to get an H-4 right away, consider coming here on a B-1, B-2, and doing a change of status later. There's different ways to navigate this, but you probably need more help from your company's immigration lawyer to help you figure out the best way to navigate this right now.
Thank you. Thank you so much, Sophie, for patiently taking up all of these questions, complicated ones as well, and comprehensive ones as well. And we do have two more viewers who've joined us, and I do not want to leave them, sad so quickly, if you don't mind. Let's go through. Let's rush to Porush. Yes. Can I file H1B through my friend's company and find another employer by July 1st and transfer out to the new employer if selected?
No. That's the answer. Look, if a company is going to, first of all, one person, one lottery chance. Don't have more than one company put you in. Second of all, the company needs to be making a good faith offer of employment when they're putting you in the lottery. They have to intend to employ you after October 1st. Third, if somebody gets selected but then a jobs change situation arises, you can't sub in another employer on July 1st. You have to get the first H-1B approved, and then later in fall, after you've worked in the company on H-1B status, then you can change to another employer in the future.
Thank you. Thank you for taking that up for Porush.
Mm-hmm.
Now, the last one for today. Thank you, folks, for joining already. This is Naga Santosh asking, "Hi, I'm seeking some advice. I'm on H4 visa with an expiration date February 2026. Due to old passport's expiration date, my I-94 admit date was shortened to July 1st, 2025, when I arrived at POE on October 5th, 2025.
Mm-hmm. Mm-hmm.
Sorry, there's a continuation. What are my immediate options now in regard to above situation? Can I travel to another country and re-enter back to the US in a same day to get the I-94 updated? Sorry, that is
Yeah.
June.
Yeah.
May.
Okay. The safe conservative thing, if you're not working, is to simply have your husband's employer, their immigration law firm, file an extension of status for you without leaving. That's the most conservative approach. So you can just stay here. There's another thing to chat with them about called automatic revalidation, which is something where you can pop into Canada, Mexico, or an island, and then pop back in and get a new I-94. Definitely speak to a lawyer before you do that to get more details. But yeah, you're going to have to take action by May 10th to make sure that you don't fall out of status. So it is good that you're watching this, and you should do something. And those are some of the options.
Thank you so much, Sophie. Okay, Porush is back with more questions. Are you? Would you like to maybe just give quick answers?
Okay, quick answers before we wrap up. These will be the last two.
Sure.
Or last one, yeah.
How long minimum do I have to work for the H1B filing employer before I could transfer out to another company? Can the employment with H1B filing company be part time?
My minimum recommendation is to get at least 3 paychecks. And yes, the employment can be part time.
Okay. Thank you
Cool.
so much, Sophie,
You're
for really doing this today. I wish we could go on and on because I'm sure folks also are joining us, but we will have to save this for some other time again, everyone out there. Thank you so much for all of your questions, for participating, and please do not forget to subscribe to our channel at Immigration Talk Show. But Sophie, really, I mean, such a great session. I really wish it didn't have to end so quickly.
Thank
But
you.
before we
The time
leave, do you
flew.
have anything else to add or to say to all the
Oh,
folks
just
watching us?
you have a wonderful audience, Nipasa, and so many great questions. And I can tell so many people are, so dedicated and so focused to having that security and freedom in their lives. And I hope the answers I could provide can help a little bit, provide another candle of light on the journey for everybody. It's an honor to be here, and I really appreciate the opportunity. So thank you.
No, the honor and pleasure is all ours, really, Sophie. I'm already looking forward to having you back again, and
Thank you.
I will do that. I mean, speak to your team for
Okay.
that. So
Thank
thank you
you.
so much once again. You have a wonderful day and a wonderful H1B season, I would say.
Thank you so
Busy, but
much.
good, I'm sure.
Thank you. Thank you. Appreciate the opportunity. Talk to you soon. Bye bye.
Thank you. Bye bye, Sophie. So, folks, please feel free to also contact attorney Sophie Alcorn, and that you can do so by calling her on her number 855-644-2581. And it would be best really to leave her a mail with all your questions, all the details about your case. And you can email her hello@alcorn.law and go visit www.alcorn.law to get to know more about attorney Sophie Alcorn and, of course, Alcorn Law. Once again, thank you so much, Sophie. It was really lovely having you. And folks, do check her out. If you also want to contact me, you can email me as well at nipa@staffingly.com or call me on my number 408-335-6444. That said, I hope you resonated with this session today. Naga, I'm so sorry about the wrong dates, January 1st, not July. Thank you. But the answer remains the same. And Porush also saying thank you. Thank you, Porush. And yes, subscribe to us and do not forget to share our content. So, at Immigration Talk Show, once again. Thank you once again, friends, and have a great day. Stay tuned on Immigration Talk Show because there are so much more lined up for you, and I'm sure you're going to enjoy. So, thank you once again.